if an individual is being represented by a defense lawyer as being incompetent, and an expert is either retained or appointed to examine the individual on the issue of incompetency, it's of vital importance that the individual who is the expert have access to all the material relevant to the case at hand, as well as the mental health background of the individual that is being examined by that particular expert. That includes offense reports, that includes notes taken by a peace officer, for instance, that may or may not be in an offense report. That includes mental health records, if there are any. Sometimes an individual may not have a record of mental illness that rises to the level of incompetency. For instance, an individual may not be hospitalized, but any relevant conduct that neighbors, friends, relatives can provide to the examiner that support the bizarre nature of the activity of the person being examined, those matters are extremely relevant for the individual to make a determination, that is the expert, to make a determination as to whether or not the individual is incompetent to stand trial. The very fact that you have, as a defense lawyer, the ability, if there is credible evidence to suggest that the individual might be incompetent to stand trial, you have the capacity to obtain an immense amount of discovery that might not otherwise be relevant to any other issue. For instance, past conduct on the part of the individual to suggest incompetency. Incompetency, by the way, might equate into an insanity defense. I have a situation now where an individual has been determined to be competent to stand trial, but has been determined by the same expert to have been insane at the time of the action, which is an unusual fact situation that I have to deal with. But it's of utmost importance that the defense lawyer uses, if credible, the incompetency standard to obtain as much discovery that might otherwise be inadmissible or non-obtainable in order to put forth this issue to a judge or jury.